Thank you, Mr. Chairman. Chairman Johnson, Vice Chair Wilson, Ranking Member Weinstein, and members of the Senate Armed Services, Veterans Affairs, and Public Safety Committee, thank you for this opportunity to provide opponent testimony on Senate Bill 172. My name is Gary Daniels. I'm here representing the ACLU of Ohio. Senate Bill 172 has been framed by its sponsor as preventing and outlawing future situations similar to and the same as the recent controversy in Boston involving a municipal judge, a person with business before her court, and Immigration, Customs, and Enforcement, otherwise known as ICE, of course. It was also claimed SB 172 will override two local rules recently adopted by the Franklin County Common Pleas Court prohibiting the arrest of persons without a judicial warrant or judicial order in a courthouse or on courthouse grounds. While such a goal by itself raises questions about the separation of powers between the legislature and the judiciary, SB 172 can also be easily interpreted as doing much more. Indeed, SB 172 can be read as authorizing state and local law enforcement to enforce federal immigration laws. And with regard to enforcement of immigration laws, I trust this committee knows, and as the sponsor acknowledged during her testimony, immigration laws are federal laws. Therefore, the responsibility for enforcing those immigration laws belongs to the federal government. State and local law enforcement are permitted to provide specific limited assistance subject to formal processes and prior approvals. However, SB 172 could or would allow much more. For instance, with regard to ICE detainers. When local law enforcement detains a suspect and ultimately processes them for admittance into jail, their identities are run through databases, including to ultimately determine the immigration status of the person detained. Sometimes, when ICE has particular interest in a person detained who is suspected or known to be an undocumented immigrant, they will formally send that jail a detainer request. This request asks the jail to hold the person up to 48 hours after they are otherwise free to go, to give ICE time to take physical custody of the suspect. This presents constitutional problems. That is, the ICE detainer request is just that, a request, not a legal requirement. Plus, as mentioned, the person in question is otherwise free to go, having at least temporarily resolved any local or state legal matters keeping them detained in jail. Without a warrant authorizing ongoing detention, local jails run the risk of lawsuits and paying monetary damages, arguing this continued detention without a warrant is a constitutional violation. Indeed, courts increasingly agree this extended detention because of ICE detainer requests is unconstitutional. However, SB 172 rejects or ignores all this, with its outlawing of any local law, policy, etc., that has the effect of or purpose to, and you can see in my written testimony there, I take a cut and paste from the legislation demonstrating in bold where we make these assertions. If it is not the intention of SB 172 to prohibit local laws and policies regarding ICE detention requests and non-cooperation with those efforts, it should be amended accordingly. Now, with regard to local and state law enforcement enforcing federal immigration law, SB 172's language can also be interpreted as granting local and state law enforcement broad authority to enforce, via arrest, detainment, and jailing, federal immigration laws absent any formal agreement or arrangement with the federal government as required. Again, I have cut and pasted the legislation there in front of you. It's essentially the same one as up at the other part of the page with slightly different bold marks for emphasis. And while it is true SB 172 contains language, quote, subject to protections afforded under the United States Constitution and the Ohio Constitution, end quote, we do not believe that language necessarily limits law enforcement and governments from detention of people pursuant to ICE detainer requests or larger aspects of immigration law enforcement by local entities. Finally, with regard to separation of powers, SB 172 intrudes upon wholly judicial matters by the legislature. This includes the authority and ability of judges in this context to enact and enforce policies and rules regarding their courtrooms and to issue a variety of rulings and orders. At the ACLU of Ohio, we are admittedly not experts regarding separation of powers issues. It is not an issue typically central to or relevant to our work. Surely, others with more experience and knowledge can and will weigh in on this matter. But we also note this general issue has been present with recent legislative attempts to restrict and end policies regarding the carrying of weapons in a courtroom. With regard to that controversy, judges have maintained those legislative efforts violate separation of powers. Given that, it is hard to imagine SB 172's mandates and prohibitions will not lead them to the same conclusion here. In conclusion, if SB 172's language is eventually explicitly limited to the conduct of judges and court actions, there will still be problems. If SB 172 is indeed meant to apply to all kinds of other immigration-related situations, actions, and enforcement, only some of which are identified in this testimony, then there are numerous additional problems and concerns. For these reasons and more, the ACLU of Ohio urges this committee's rejection of Senate Bill 172. Thank you, Mr. Chairman.
Very welcome. Questions? Okay, seeing none, that'll constitute that testimony. Thank you so much.